Good morning, everyone, and welcome to this year's Employment Law Seminar. And thank you for joining us today. We'd like to welcome you to our session. It's great to have so many of you join us. For those of you who are new to our free events, we run monthly webinars, so please do check out our events page on the website. For those of you who are regulars with us, welcome back, and it's great to have you join us in our seminar. A copy of today's slides will be shared with everyone after today's event, so please don't worry too much about scribbling away. So before we get started, we'd like to introduce ourselves. I'm Victoria Templeton, HR Knowledge Manager here at HR Solutions, and today I'm joined by Sue Watson, Head of Client Services. So together we'll be taking you through what you can expect for the year ahead in employment law and obviously answer all your questions. For those of you who are new to joining our virtual events, HR Solutions is an award-winning HR consultancy. Our head office is in Kettering, and we provide that expert HR, payroll and health and safety services to a wide range of clients, from businesses with less than 10 employees to multinationals with over 200. And so with that, I'd also like to introduce you to our technical support today, Drew, who will be here on hand to help us should there be any technical problems. Fingers crossed there won't be, but we have Drew on hand as well. So also, if you experience any technical issues yourselves and you can still use your GoToWebinar dashboard, please do reach out to Drew just in case it may be something our end, but hopefully not. So we've got lots of you who've joined us today, and we've placed you all on mute, but we do want to hear your questions. So when you see this slide throughout, Sue and I will be ready to take your live questions. We're doing it slightly different today to what we normally do on our webinars. We've broken our seminar into sections, and we're going to be taking questions at the end of each section. So please do post throughout as we're talking any questions that you may have, and we'll look at answering them at the end of each of those sections, and then obviously continue to raise questions throughout the webinar, because there will be a final opportunity right at the very end just to finish off with any remaining questions that have still cropped up. So I'm just going to run through how you can submit your questions. On the screen now, you'll see an image of what your GoToWebinar panel looks like. So simply type in your question in the questions pane, and then Sue and I will read those throughout as we go through the seminar. So when you see this slide, it means that we're going to be seeking your views and thoughts on the subjects that we're talking about, and then Sue and I can have a discussion on those subjects. It's a good way of having that interaction because obviously we're remote and we're doing this virtually, and we don't have the opportunity to talk in person as we normally do, like a face-to-face seminar. So we'll be using lots of interaction activities throughout the session as well. So we would be really grateful if you can contribute your views and thoughts to that. And so let us begin. And as you can see from the agenda here, we're going to cover, first of all, the key developments of last year. There's a few significant developments that came through that I'm sure probably you'll know already what I'm going to probably cover, but I want to just summarise what those developments were last year. Then obviously the main theme for today is looking at what the employment law horizon is at the moment for 2023, what we can expect to see, the progress of employment legislation, and then we're going to finish with our final section where we're going to share our practical tips and guidance for how your business can prepare for the changes, and like I said, take any remaining questions as well that will have come through. And so to kick off our first section, where we're going to be looking back over 2022 at some of the key developments, we want to just get your views and thoughts on these areas from your perspective. So, Sue, if I could invite you to run the polls.
Good morning,
so
everybody.
What we're
sorry.
Yeah. Sorry, go on then, Sue.
So right, we're going to run. Initially, we're going to run 5 short polls. They are short. They're mainly yes or no answers, and so we're going to run them consecutively. But we will discuss the results at the end of each one and share them with you. So let's launch the first one. which is, do you employ people who work part-year or irregular part-time hours? And we're off.
Pardon?
And we're off.
Yeah.
Okay.
Yeah.
Still coming through. Hang on. Right, I'll close that poll and share the results with you. Oh, what about that? 50-50.
Let's have a look. Oh wow, is this a first?
I think it
I
is
think
a
it might
first.
be first.
Straight down the middle. Okay, I will move on to the next one. So the next question is, do you employ people on 0 hours contracts? Okay, I'll close that one and share the results.
Okay.
Now there's a bit of a difference on this one. So
Okay.
majority no, but there's still quite a significant number do.
Yeah.
Okay, let's move on to the next one. Number 3 is, do you employ people who earn a weekly wage that is less than the lower earnings limit? Okay, I'll close that one and share that. So we have majority no, but still quite a few that do.
Yeah.
So number 4 is, do you have an annual leave policy that sets out what happens if leave is not used at the end of the holiday year? Okay, I'll close that one
Yeah.
and share. So the majority have. So
Okay.
that's good.
Yeah.
And I'll load the final poll for this section. Do you proactively encourage employees to take all of their annual leave? I'll close that final poll now and share those results. So as
Okay.
you're all probably gathering, this is all quite useful information, and we will be addressing the statistics as we work through the next section. So thank you all for responding so quickly as well and participating in that. So I'll hand back over to Victoria.
Thank you, and thank you everyone for sharing your thoughts there, because actually they're all relevant questions to our next section, because we're going to look at exclusivity clauses, calculating holiday pay for part-year and irregular hour workers, and backdated holiday pay. So it's really helpful to have your business context there. And so to begin with, we're going to look at the first change that occurred last year that's significant, and that's a piece of contract law that came in, and it's regarding exclusivity clauses. So for those of you that employ people who are on 0 hour contracts, that's 33% of you, you'll probably, well, you will already be aware of the legislation around that. And then for those of you, 14% of you employ people who have a weekly wage of up to £123 a week, then this is going to be relevant as well. So exclusivity clauses, what are they? Well, it's essentially a clause in the contract of employment that it prohibits a worker from carrying out any work or providing a service under another contract, or prohibits a worker from doing so without their employer's consent. Now, they were banned from being used in 0 hour contracts way back in 2016 under the exclusivity terms and in 0 hour contracts redress regulations of 2015. But last year, on the 5th of December, the ban extended to all types of contracts of employment, not just those employed on a 0 hours contract. And that legislation that came in on the 5th of December is called the legislation, the exclusivity terms for 0 hour workers, unenforceability and redress regulations of 2022. And so it applies for workers who have a guaranteed income at or below the lower earnings limit. The lower earnings limit you'll be familiar with because it's used in other pay calculations like your statutory payments, but it's set at £123 a week. And we've had news in the last few weeks that it's going to stay at that in the next financial year as well by the government. So that's £123. So if you employ people who on any type of contract and their income is lower than that £123 a week, then it's unlawful to restrict them taking second jobs. So you can no longer restrict them from doing that if their earnings fall below that threshold. And I guess we're going to typically see sectors such as hospitality, health and social care, probably workers in that sector most likely to benefit from that greater protection because it's enabling them to find other ways of increasing their income. So that was a significant change that came in at the end of last year on the 5th of December. And the next key development from last year is around holiday pay. And if I said the Harpur Trust versus Brazel case, I'm sure most of you, if not all, will know it's going to be our focus because it was a significant piece of case law that came through. And it all deals with holiday pay for those working part year or irregular part-time hours. So 50% of you on the seminar today employ workers that would fall in that category. And so it's obviously very relevant, but it will obviously be relevant to everybody else because, you know, the ruling has implications for other types of contract, as I'll come on to say. Now, the Harpur Trust case dealt with the issue of calculating holiday pay, not holiday entitlement. And that's the important thing to remember. It's about pay for somebody when you don't know what hours they're working. So Miss Brazel is employed as a music teacher on a 0 hours contract, given hours that are based on the demand for music lessons and therefore paid by the hour as well. But way back in 2011, so this is a case that goes back years. So back in 2011, the trust changed the way they calculated holiday pay. And the new method left Miss Brazel worse off in terms of what she would receive in holiday pay. The trust used what we know very well as being the 12.07% method. Now that has been widely used across most businesses for some time, and even ACAS have recommended it for some time. But what Miss Brazel was arguing is that it didn't give her full annual leave paid entitlement under the working time regulations. She was arguing she was only getting a prorated amount of holiday rather than the 5.6 weeks. So she complained to the Employment Tribunal for unlawful deduction of wages because of that underpayment of holiday pay. And in 2015, that's when we first had the very first court case, went to the Employment Tribunal, and they found in favour of the Harpur Trust. They agreed the 12.7% method was lawful because it gave her proportionally the same holiday entitlement as a full-time, full-year worker. But in 2018, the Employment Appeals Court then overturned that decision and actually found in favour of Miss Brazel. They found, in terms of the regulations, that there was no reason to depart from the plain statutory language of the working time regs, and that the intention of the working time regulations was that all workers are entitled to 5.6 weeks of paid annual leave. There was nothing in there that gave a basis for prorating someone's entitlement. And it's gone through the courts. 2019, the trust appealed to the Court of Appeal. They argued that, you know, the 12.7 method was necessary because otherwise you'd get unjust results. How can you have some employees being in receipt of the same amount as holiday as a full-timer. So they took it further and appealed to the Court of Appeal. But ultimately, the Court of Appeal ruled that even if it meant that favourable treatment of part-time or part-year workers occurred, it wasn't an issue because it aligned to the workers' minimum rights under the working time regulations. There's nothing set in legislation that says you can't favourably treat somebody. All the legislation as it stands says you can't unlawfully treat somebody unfairly. So it went to the Supreme Court, the highest court, and it was heard, I think, in the December of 2021, and it wasn't published until many months after last year. And the Supreme Court held in favour of Miss Brazel, and they published their ruling, their judgment, and it's significant because it confirms that under the working time regulations, a permanent worker who only works part of the year is entitled to the same annual leave as a permanent worker who works full year, which is the full 5.6 weeks, and that it's not to be prorated. So when someone works irregular hours, irrespective of whether it's a full year, part year, employers must find that fair, equitable and non-discriminatory way of calculating holiday entitlement and pay. Now, the judgment is significant, as I've said, even though if you don't employ people on part-year arrangements for irregular hours, because the judgment only dealt with 0-hour contracts and those working part-year, in this case you work 34 weeks, but because the working time regulations applies to workers, which is a broad definition, it's legally considered that the principles in this case may also apply to other forms of working, where there is a contract that's permanent and continuous, and where the worker's not working every week. So we know it can work for 0-hour contracts. It will also apply to casual workers who have that overarching umbrella contract, and casual workers, or even full year workers on a full year but on a continuous permanent contract. So even though she was a part-year worker, it has ramifications for other types of contracts of employment. But for clarity, it doesn't apply to part-time workers who have contracts of employment with regular hours, so set hours or set days, week in, week out. It doesn't cover casual workers who aren't engaged on a permanent basis throughout the year, so that not having that umbrella overarching relationship. It doesn't apply to workers on fixed term contracts, those short durations. And also, as you already know from the working time regulations, when we operate leave for employees in their first year of joining and their final year of service with an organisation, it doesn't apply in those 2 years. So it does have significant ramifications. And I think, it doesn't give us an answer as to how to calculate holiday pay, because how do you know what to pay someone? If they take 1 week's leave of their 5.6 weeks entitlement, if they've got no set hours or do not work throughout the year, how do you know what 1 hour equates to? So unfortunately, all that we have in writing is how to calculate average pay, because we know that from the Employment Rights Act, there's a clear method there. What we don't know is what method to use to find out how to work out how many hours that somebody would work and therefore how much to pay for periods of annual leave. And that's the difficulty. But ultimately, the key message is if you employ those workers in those forms of contracts of employment, they must get the full 5.6 weeks annual leave paid, and you can't prorata holiday. So that's a massive piece of case ruling, and even legal professionals and the HR community, everybody has struggled to get their head around it. It's very complicated. And then moving on to another significant case ruling that came out last year is Smith v Pimlico Plumbers. And this again is a long-standing case that goes back to 2011. And it's been back and forth, but for various reasons. It started off being a case about his employment status. So initially the employment tribunals and Supreme Courts considered whether he was a worker or self-employed. Obviously, if he was a worker, then it would mean he'd be entitled to holiday pay, for example. So that went through the courts, and ultimately, in 2018, it was ruled by the Supreme Court he was a worker, meaning he was due backdated holiday pay. So a year after, he then lodged a new claim at the Employment Tribunal for backdated holiday pay. So now we're dealing with a different type of claim. So he went and took it to the Employment Tribunal, and he argued that since his status was confirmed as worker, he was due back that backdated holiday pay all the way back to 2005. But the original tribunal and the appeal tribunal held the view that he had not filed his claim for that backdated pay quickly enough, and he lost his claim, because they deemed that he should have made his claim for missed pay within 3 months of each holiday period dating back to 2005. That's what the current existing tribunal rules are. A claimant must claim for any missed pay within that 3 months of each holiday period. But Mr. Smith appealed that Court of Appeal judgment. Now, the Court of Appeal ruled that he was entitled to, well, he claimed for £74,000 worth of backdated holiday pay, because he argued at the Court of Appeal that the original courts hadn't correctly applied the law, and they mistakenly concluded that he had not been able to show it was not reasonably practicable for him to bring his claim. He also argued in the case of another ruling, King versus the Sash Window Workshop, that somebody who was self-employed in this case was found to have worker status, and they successfully argued they were entitled to holiday pay for 13 years. So he brought that other piece of ruling in. And ultimately, the Court of Appeal upheld his appeal, and it is a landmark ruling because they've allowed him to claim that back holiday pay for that periods where he was incorrectly classed as a worker. And in that ruling, it outlined that whilst domestic legislation can provide for the loss of the right of annual leave at the end of a holiday year, and to lose it, the worker must have actually have had the opportunity to exercise the right. And that's ultimately they summarised as. So in terms of implications for employers, it's important that there's clarity in the communication around your holiday pay, which is why one of the polls was around your annual leave policy. So 92% of you said that you do have clear rules in place as to what happens if you don't use it. So what the tribunal, the Court of Appeal, has ultimately said is you must give the workers the opportunity to take paid annual leave in the first place. You must also encourage workers to take paid annual leave, and 91% of you answered that you do. And you must also inform the worker that right to paid annual leave would be lost at the end of the holiday year if it wasn't taken. So there's some really significant findings on the back of that, and it really just reiterates the message about the need for having clear, well communicated policies, because that is an example of how you must ensure that people know to take annual leave, that they're encouraged, and they know the implications for them personally if they don't. So that's a significant piece of case law. So before we move on to the next stage, which is all about 2023, just want to see if there's any questions that may have come up.
Yeah, we have one or two.
Okay.
First of all,
anything to do with Harpur Trust?
Yeah. So the first couple of questions are around clarification for starters and leavers. So
okay.
Can you still prorate for leavers and for somebody who joins part of the way through the holiday year? Which is okay, you can still do that. I think it's
because there's a specific provision in the working time regs that addresses that says you can, and that's not being changed or challenged in that case.
Yeah. And then the next one is, does it apply to part-timers who do regular overtime? I guess that's in the calculation of hours.
So So part-time workers who work irregular hours but also do regular overtime, is that what you mean? Or are they
I think
regular part-time hours?
regular part-time who do regular overtime, I would
Yeah,
imagine.
no, so the ruling doesn't apply if you have part-time workers who work the set number of hours week in, week out. The days may vary, but essentially you've got that regular pattern of part-time work hours. The ruling doesn't apply. So
Yeah.
I work Tuesday to Friday, the ruling doesn't apply to me. If you have somebody that works perhaps 4 hours one week, no hours next week, 7 hours the following week, bit hit and miss kind of thing, that ruling applies to those kind of workers and those hours arrangements.
Yeah. So the next question is around compressed hours. So if somebody works compressed hours Monday to Thursday, should the holiday entitlement be in hours or days, and how should this be calculated? I think this is a big confusion for many of us. I
Yeah,
include myself in this, but basically you still get 5.6 weeks leave minimum
yeah,
entitlement, and Monday to Thursday is your week. But if you
yeah,
are working different hours on each of those days,
yeah,
then it might be worth using hours so that you don't take, you're not deducting a full day when you're only, if the days are irregular or different. Do you agree, Victoria? Because you've obviously got the
yes.
bank
So
holidays as well, depending on if Monday to Thursday, then the
yeah,
bank
if you're
holidays
working,
would be in that, wouldn't they?
you still get your 5.6 weeks because a 1 week to that person is still 4 days. 4 days is 1 week, and they get 5.6 lots of that. The working time regs don't have a maximum working day written within it, does it? So
No.
they still get the 5.6. And then, like you said, then if you operate holiday entitlement in hours, there may be ways then to, so if they take a Tuesday off, they're taking the number of hours that they're working off on that Tuesday, aren't they?
Yeah.
Yeah,
Which is
but
either
it's
a day
still
or
5.6 weeks.
hours if you've got an hours policy. But it's because
Yeah,
the day is perhaps 12-hour day, or is a 10-hour day, as opposed to a normal Monday to Friday worker,
yeah,
maybe on a 7 or an 8-hour day, perhaps.
yeah. It
And
doesn't distinguish it, does it, in the
no,
legislation, the length of the day?
no.
No.
And it's more affecting pay. As long as you pay them what they're due for a day's
Yeah,
work, then that that's the bit that's correct. The entitlement is still the same.
yeah,
So in relation to paying the pro rata leave to a leaver, they have an enhanced annual leave policy, but when employees leave, only statutory holiday is paid.
yeah,
Is it acceptable? I think that's acceptable if it's in your
yeah,
contract, isn't it? As long as you contractually say that is what will be applied
yeah,
on leaving, then
yeah,
yes.
yeah,
Otherwise, if you are say you're entitled to your full entitlement and don't clarify it's statutory only,
yeah.
then you potentially breach a contract if you don't
Yeah,
pay
so it's
for
all how you're
entitlement.
wording the contract clause, isn't it? But
Yeah,
essentially, going back to the regulations again, it's the statutory element only that deals with prorating that first year and final year.
yeah.
So you can make
Uh,
whatever decision on the enhanced bit, can't you?
yes,
Yeah,
absolutely. And that's just up to you to make sure the contract is clear on what your enhancements are
yeah,
and what the rules you apply to the taking of them and to the payment of them on leaving.
yeah.
Um, so if we offer our employees more than 28 days holiday, including bank holidays, does that figure override the 5.6 weeks when looking at 0 hours contracts?
Can you repeat that?
Yeah, so if they offer enhanced holidays,
Yeah.
does it override the 5.6 weeks when looking at 0 hours contracts? Not sure
In
if that's in
terms,
entitlement or in calculation, but
so the Harpur Trust ruling applies to statutory leave only.
so that they could have a different ruling for the enhanced again. It's the same as we
Yeah,
were just saying, wasn't
yeah,
it? That
yeah,
if you enhance the leave above statutory, you can apply whatever rules you wish to the
yeah,
taking or the management of that leave,
yeah,
that element of the leave, in terms
yeah,
of carry forward or otherwise, or paying in lieu of it. some of you like to pay in lieu of leave
Yeah,
not taken at the end of the year. You can do that above the statutory leave.
it's just,
And
yeah, the statutory you can't.
statutory leave has been taken as well. Oh, a question about the claim. Was the full £76,000 paid?
74,000. The Court of Appeal.
The
I
plumber one,
haven't
I said that
heard.
one first too.
Hmm?
Yeah, I think they have got nowhere else to go, have they?
No.
No, so
nothing's been published on that.
on that yet.
So
I don't think there's any more. They can't go any further, can they? So I would imagine they would have to.
well, it was the Court of Appeal that gave the ruling. So whether there's any basis for the Supreme Court.
Again. Yeah.
But there has to be legal grounds, isn't there, for when you appeal to higher courts? Can't just be there's got to be on a legal basis, hasn't it?
Yes, absolutely.
There may no longer be a legal basis to fight it further.
Yeah, that's what I was wondering. Is there a law about rolling over a certain amount of leave to the new year?
Again, it's up to an employer how they manage and what policy they have for holiday. In terms of the regulations, trying to think if
there's no statutory right to, unless you are
it's
on
a company
maternity leave,
decision,
isn't it? Or unable to take it, or
yeah.
on long term.
So whilst there's no statutory anything worded as such in the regulations, what employers must be mindful of is the whole purpose of annual leave. It's from a health and safety perspective for giving people rest breaks from work and periods of time out. And so when it comes to making decisions on policy, you've just got to be mindful that it doesn't breach that in any way. So you're still able to give employees a fair break from work throughout the main holiday year. But in reality, nobody's going to put most of the holiday in as a carryover, are they? People generally limit it to 5 days or so, don't they, or 3? Yeah. But yeah.
And often people restrict it to once, for enhanced policies, once you have taken your statutory minimum leave, anything above that you can carry forward, but only once you've taken your statutory minimum leave, because obviously there is the health and safety element as well.
Yeah.
So there's a challenge. This is an anonymous poll, anonymous question. If overtime should be taken into account when annual leave is paid, what should somebody do if this has never been done? I think we'd probably say address it going forward.
Yeah, I think so try and understand what your position is first in terms of the financials and the extent of the problem it has, the risks it leaves the business in.
Yeah, and then take a decision on perhaps
and then it's making a view on that.
Yeah.
And how you want to make it. It's a commercial decision as to how you then manage that situation, because it might mean that there's some form of resolution via settlement, if you that kind of thing,
or an agreement to kind of draw the line and put it right going forward.
Yeah.
So the holiday calculation for part-time workers who do not work the same amount of hours but work the full year.
Okay, irregular hour workers.
Who do not work the same amount of hours but work the full year. Yeah.
Yeah, okay, so they're covered by the Harpur Trust ruling. So they're irregular hour workers. So they're asking how they work the payout.
I think it's what is the holiday calculation? So it is based on the
so
ruling, isn't it?
Right, yeah. So the difficulty is we haven't got anything written down or that's come out definitively. So you know that they must get 5.6 weeks of paid annual leave. What you don't know is what 1 week means for that worker. Is it a 2-day week? Is it a 10-hour week? That's the thing that we don't know. So we would advise employers to get the data together of the hours that they've worked. I'd probably go back 50, probably more than 52 weeks. I'll probably go back to get 2 years or 18 months worth of data, because you don't know what their pattern of work has been like. And you need to take an approach that's reasonable and fair, and trying to get an average of how many hours a week or how many days a week somebody has worked is the next best thing in the absence of anything definitive being written or that's come out with a ruling. So you would look to find an average, first of all, of what an average week looks like. So is it on average I work 10 hours? Is it on average I work a 4-day week, from how you've looked at how my hours have worked over an X period of time? Now, what that X period of time equates to, how far back you look, isn't set. It's not a blanket approach. You have to consider each individual separately, because you may have one worker that works every week of the year, but their hours vary every week of the year, versus another worker that comes in for a period of 4 weeks, works irregular hours in those 4 weeks, then doesn't come back and provide work until 4 months later. So you can't use the same averaging method for those two examples. So that's why you have to look at each person individually. So if you can work out an average number of hours or an average number of days an irregular hours worker works, using a reasonable reference period to get that average, you can then work out your pay, because you can narrow it down to knowing what 1 hour work equates to in pay, because you know you've got your averaging method set out in the Employment Rights Act. So you have to look back your 52 weeks, exclude periods where there's been sickness, and then you find out what the average hourly pay is, and then find out what 1 hour is in pay.
Yeah,
it's complicated. That's all I'd say. But
it's better
I
when
think
it's written down. I think you can really look at
yeah,
it and reflect on it, rather than kind of hear it all there. But the
yeah,
principles of how you do it, it's just to be fair, isn't it?
yeah,
And how you do it, apply it, and every circumstance and possibly every individual in your organisation might need a different
yeah,
period to review over, that's one of the questions actually. Somebody was, can you pay sort of a 0 hours worker based on their previous month's hours? And I think that's potentially, I mean, you could, there's no rule to say how you do it, but if they were fairly similar each month.
yeah. The thing, I mean, no, I mean, there's probably several areas or ways in which you can probably do a calculation. Nothing's been tested. That's a challenge. Nothing's written down. The only thing we know that's concrete you have to do is the Employment Rights Act tells you how to work out the average pay. It's in black and white. That's the only bit that we know. The bit that is the hard bit is working out an average for somebody. But if you can look through a reasonable period of time back of how they've worked their hours to get a fair assessment, you can then get a fair average. And I'd probably say engaging with your worker, talking about how you've worked it out, calculated, is probably important as well, because you want to get them on your side and you want them to understand how you're managing and calculating their pay. And then if there's any challenges, you can try and resolve it and deal with it and see if there's a different way of doing it. but it's complicated.
It is.
Even we find it complicating.
I suggest, just because of the time, that we have got a few more, but we'll save them to the end. If we have time at the end, we will come back and regroup on these. And if we do run out of time completely, we will respond to you directly afterwards. So, but I think we've covered mainly all the topics that have been raised. There are just one or two sort of sub questions there, but let's continue, and then we can pick it up later, hopefully.
Really good questions. Thank you. Keep questions coming through.
Yeah, keep sending them. And somebody asked about how they could send a question slightly off the topic we're doing. Send them through, and we will cover them at the end. So please do send all your questions in.
Happy for any questions. There you go. I've said it now, Sue. So we're going to now look at employment law for 2023. And I guess you'll all know there's probably been little development in terms of employment law other than COVID regulations have been about. And so what I think this year now, there's a lot going to be going through Parliament, and this is what I'm going to be taking you through. So I think it's going to be full steam ahead. Many have been in the pipeline for a long time. A lot of things got put on hold because there wasn't parliamentary time to progress them because of the pandemic, etc. But I think it's full speed ahead. So we're going to see some developments this year coming from various sources. So first of all, we're going to have the legislation. There's a few that we know are definite and that are happening. Then we have employment bills, and there's tens of them. There's lots of parliamentary bills currently working their way through the House of Commons and the House of Lords, and that, we're going to go through some of those. And then we're expecting some interesting case rulings this year, which could have implications for how business operates. So for those of you who are users of our knowledge base, you'll find a legislation tracker that will keep you updated as the items progress through Parliament and into law. You can keep a track in our monthly newsletters that we publish, which links into our other resources, so our articles and templates. So you've got all that there. And if you don't have access to our knowledge base, then you can, there's certain information you can access through the main website because we have an employment tracker. And then you can sign up for some other forms of weekly updates. So that's what we're going to sort of focus on now, the legislation and employment bills, and see what's going to be coming about. So in terms of the legislation, so there are a few things we know that are happening. So this month, the harassment in the workplace is a big focus because this time last year, the UK ratified the International Labour Organisation's Violence and Harassment Convention. So it's just its commitment. It's signed up with many other countries to sign up to that. And we are going to see some developments on sexual harassment legislation, which I'll come on to talk about. Then, of course, in April is the usual statutory payment increases. So we're going to see changes to the national minimum wage, changes to all our family-friendly statutory rates and statutory sick pay. And then in December, I've put this on here, whilst it's not definite in that it's not been signed off and given royal assent, it is a really, really critical employment bill. It's the retained EU law reform and Revocation, I can never say it, but the reform bill, as I call it in short. So essentially, that's going to be vital, because if that gets passed, and we suspect it will, then ultimately it's going to have massive ramifications for employment, which I'll come on to. So just to summarise, here on this slide here are the statutory rates and what they're increasing to. So you'll see all the national minimum wage rates here that will be going up, and statutory sick pays are being increased up to £109.40. And then for our statutory family friendly payments, the week's pay is going up to £172.48. So they're going to be taking effect from April. So other than those, we've not really got much in terms of concrete dates. So a lot of this section now is about our employment bills that are going through the pipeline, and there are many. So I just thought I'd run through how it works, because when an employment bill gets published or introduced rather, then there are several paths before it gets given the royal assent. So first of all, it has to go through the House of Commons. So that involves having 3 reading stages. There's a committee stage and there's a report stage, and throughout each of those stages amendments can be made and they get debated and amendments are accepted or declined, but essentially that's how the bills get debated and refined. Then the bill passes to the House of Lords, and again there's 3 reading stages. Again, amendments can come forward and be considered. There's a committee stage and again a report stage. And once it's been through both of those houses, then it then goes through for the final stages where consideration of the amendments are given, and then ultimately the royal assent is given and it becomes an act of parliament. And when it becomes an act of parliament, it can be either effective immediately, it can be effective either after a set period or only after a commencement order. And there's actually a piece of legislation that I'll come on to talk about that is an example of how it's not come in place immediately, but there's going to be some point in the future. So that's the employment bills. So there's plenty on the horizon, and I've broken it into 4 sections. So you can see there's the first section, which is about the EU Reform Bill and the areas that it's likely to impact. You've got several bills relating to family rights. You've got several bills that are of an equality in nature, and then you've got several bills that will affect businesses and their working practices. So this is just a summary. We're going to take you through these and run several polls as well, just to see and get your views and input. But these are the key areas that are going to be developing in 2023. And I'm going to start off with the retained EU law bill because it's significant. Because if it's passed, it will, in theory, revoke all the legislation that's in the UK that is based on European law, including case law, and there's thousands and thousands. It's not obviously just impacting employment, but it also impacts other types of legislation. But from an employment law where we're concerned with, then it could be the biggest change in employment changes in decades. You know, it's that massive. So if it's passed, it means that legislation can be abolished. It could mean that existing legislation is retained, or it could mean existing legislation is retained but with amendments. And there's within the bill what's called a sunset clause. Now a sunset clause is essentially, I suppose it's like an expiry date. If there's nothing happened or changed with either retaining any of the European-based legislation, then essentially it's abolished as of 31st December. So it's massive, it's significant. It's currently at the House of Lords, so it's quite a way in through the parliamentary process. It's all done through the House of Commons. It's now at the House of Lords stage, and the report stage of that is due on the 19th, or is from the 19th of April. We would always recommend keeping up to date with developments on it. We provide our regular updates on our main website, on their knowledge base, because it is significant. And I think from a day-to-day perspective, you know, we have a lot of UK legislation that's underpinned by EU law and case law. So, for example, we have the agency workers regulations, we have TUPE, we have the working time regulations of 1998, we've got various family-friendly legislation such as maternity, parental leave, etc. And even if we think back to the working time regulations, we have case law on holiday pay that's incorporated into UK legislation. So these are massive areas of employment that could be impacted significantly. So it is that big an issue. But it is unclear as to what extent we'll see developments, because as I said, legislation could be abolished. it could give Parliament the ability to amend some of the, like TUPE, working time, family friendly. It's essentially the bill would give Parliament the opportunity to abolish or amend. So in terms of where we think changes could be or the extent of the changes, it is hard to say, but I think if we think about agency workers, I mean, it's never really been a popular piece of legislation from the outset. We could see a significant change to that, or possibly could it be abolished? TUPE is a long-standing piece of fundamental important legislation. So we don't think there's going to be any major changes to it. If any changes, perhaps minor. The working time regulations are an interesting one. We know the government have talked about the working time directive in recent months over the last year. You know, we know that there's a lot of focus on UK productivity, being able to boost that, getting more people into work, you know, and there's been talk around, you know, these working week limits, should they be capped? So this is probably a really interesting one and one to keep an eye out on, because I suspect we will see some changes on that. Then we have family friendly protections, and I think I would probably be cautious. I probably wouldn't say there'll be many changes or any changes at all, just because we've had long-standing family-friendly protections in place for many, many years, and to change that I think would be absolutely significant and would be probably dangerous. So I don't think there'll be many changes to that. And then if we think about the holiday pay, then given the headache of the Harpur Trust case for everybody, even the legal profession and businesses across the UK, it's very, very difficult to manage. I think there's going to be developments on that. As I said, the EU reform bill, it's not just about legislation that it can abolish, but the legislation that gets underpinned by case rulings that have already happened. So, and I will touch on holiday pay in a moment because there's something else going on with that. So I think there is going to be change around holiday pay for irregular hour workers and part-year workers. So just when you think you've got your head around it, like Sue and I do, then I think there's going to be change again. So that's generally a summary of where we think there could be some changes, and to the extent, as I said, it's not definitive. It is still a bill going through the House of Lords, but I think in the whole context and how we know how employment laws are managed and views and how it operates, then I think that's where we've sort of gauged our assessment. So I think we've got a poll, Sue.
Yes, we have. Sorry, I was just trying to click the button and it wouldn't click. So let's launch the next polls. Just one this time at this particular point.
Yeah.
So we have: which aspect of EU law, if it was abolished or amended, would impact your business the most?
Okay.
You can select more than one answer if they all impact you the same. A few more coming in.
Okay. Interesting seeing the results.
Isn't it? Yeah, it's close
Evolve.
ones. Right, I will close that now.
Okay.
Share the results. There we go. So
Okay.
quite similar on the three bottom ones: working time, family friendly, and holiday pay, which I guess we would have
guessed the holiday pay one, I suppose.
Yeah. But agency workers and TUPE are still in there with, you know,
Yeah,
quarter
well,
of
it's
the
quite,
people.
I'd say TUPE is quite a lot actually, isn't it?
Although we're seeing it quite a lot. There's
Yeah,
a lot of our clients
probably...
are acquiring or smaller businesses
Yeah.
are being kind of swallowed up, that are struggling with the current climate. So there's a lot to be happening. And agency workers, yes. Oh my goodness, how long has that been going on for? All the debates around that.
So interesting, yeah, and definitely holiday pay the biggest impact. Yeah. And I'd or we'll come on to holiday pay shortly, because there could be some good news.
Right, I'll hide that and back to you.
Thank you. So we've had a consideration of the EU reform bill. We're going to look at family friendly rights. So a lot of the detail I'm going to go through now is what's currently in the latest version of the bill. So as I said, bills obviously go through various stages. There's lots of amendments. So obviously what may look like as a final piece of legislation might be slightly different to what we go through now, but it's a good indication of what we can expect. And I think family friendly rights, if we start off with looking at the Employment Relations Flexible Working Bill, it has been in the press a lot recently, especially because the government have recently concluded that following a period of consultation, it is going to be introducing changes to existing flexible working rights. We don't know when. As I said, it's going through the relevant houses. So, but what we know that we can expect flexible working to be a day one right, as in you have the right to ask for it. That's the main proposal. And because at the moment, currently employees, as you know, need your 20-week service. So that's going to be scrapped, that piece. So it'll become a day one right. But we're also going to see a new requirement on employers to consult with their employee when intending to decline the request. And the rule of allowing employees to only make one request in a 12-month period will also be abolished as it stands in the current bill, and instead employers will be limited to making two. So that's going to be quite significant because it's a big, it brings a big administrative process along with dealing flexible working. And if you think about it, some cases can take, you know, weeks to resolve. So that's an interesting one. And employees will no longer be required to detail the effects of their proposed changes on the employer. And we've had that in place since day one. It's something we're also used to seeing in our application forms, trying to get the employee to understand how their proposed working pattern will impact the business. Well, that bit is looking like it's going to be scrapped. So the bill is currently at the House of Lords, so it's quite a way through the stages. It had the first reading back on the 27th of Feb, and we're waiting for the date of the second reading to be confirmed. But that's a good summary as to what we're going to expect to see in the Flexible Working Rights bill when it comes through. Next is the Neonatal Care Leave and Pay Bill, and it's about introducing a law to allow leave and pay for neonatal care. And again, the content for this is based on the current version of the bill. So currently, we know outside of this bill, then a parent has to rely on using existing statutory entitlements to be able to take time off to be with their baby in hospital, such as using part of the maternity leave or paternity leave. And so it's at the moment very difficult for working parents because they have to use that right to be able to, it gives them less time to bond with their baby outside of hospital because it's taking up some of their statutory leave. So this bill is about giving a specific period of leave and pay to parents of sick children. So neonatal care is a type of care baby receives in a neonatal unit. So if they're born premature, sick, or with a low birth weight. The bill proposes to introduce a new employment leave and pay rights for employees of parents of babies that are admitted to hospital as a neonate, and that's classed as 28 days old or less. And the definition of neonatal care set out in the bill is about the care of a medical or palliative kind of care specified in the regulations that starts before the end of a period of 28 days, beginning with the day after the date of the child's birth, which is all very complicated and wordy, but essentially there's a defined time frame in which employee can take that leave for neonatal care. It would allow leave to be taken before the end of a period of at least 6 to 8 weeks, beginning with the date of the child's birth, and the leave to be taken before the end of a period of at least 6 to 8 weeks, beginning with the date of the child's birth. So, yeah, sorry, I was just, repeated that there. So it's the 6 to 8 weeks that from the birth that the leave must be taken. The relationship is also defined in the bill. So it'll be for somebody who has parental or other personal relationship with a child who is receiving or has received neonatal care. We expect the leave to be capped at 12 weeks and would be a day one right. And we expect pay to require minimum earnings, just like our other family-friendly leave entitlements that also correlate with the lower earnings limit, which, as I said earlier, is that £123. And the detail of the bill, we could put links to it after the webinar. It is at the House of Lords stage and we'll have its second reading on the 24th of March. We then look at the carers leave bill, and this would give employees who are unpaid carers the statutory right to take unpaid leave each year. And the purpose of it is to provide or arrange care for a dependent with the long-term care needs. And I think what we can see from the bill, it's based very similar to the current existing legislation around dependency leave. So as I'll come on to explain, so a person is a dependent of an employee if they are a spouse, civil partner, child or parent, they live in the same household as the employee, and they reasonably rely on the employee to provide or arrange that care. So that's essentially works alongside the dependency leave. And they define in the bill what the long-term care would be. So if they have an illness or injury, which can be physical or mental, that requires or is likely to require care for more than 3 months. So there is a time period as well. They have a disability for the purpose of the Equality Act, and they require care for a reason connected with old age. So there's quite specifics in terms of how somebody is entitled to take carers leave. Excuse me. So the entitlement is at least a week's leave during any period of 12 months. And an employer cannot require an employee to provide evidence before granting that leave. It will give protections to employees to be able to make a complaint to a tribunal. So if an employer unreasonably postpones a period of carers leave, if they prevent or attempt to prevent the employee from taking it, and then compensation must be just and equitable, including the employee's behaviour and any consequential loss sustained by the employee. So there's greater protections in the legislation, in the proposed legislation. The bill is at the House of Lords stage. It's had its second reading on the 3rd of March and is now at the committee stage, after which a final reading will take place before it then progresses to the final stages to get royal assent. So this is good timing because we have another poll, and I think I'm just about to lose my voice. So over to you, Sue.
Okay, so we have 3 short polls at this point. So I will launch the first one. And this is, do you already offer flexible working from day one of employment? We are aware many people do. A few more just coming through.
Okay.
Okay, I'll close that and I'll share the results of that one.
Okay.
So quite close.
Oh right,
the
surprising.
Majority don't, but there's quite a significant number do offer that.
Yeah, and I think it's probably a sign of thinking about recruitment and challenges with recruitment. Obviously, employers are trying to find innovative ways in which to entice people, aren't they, and to secure the right talent. And I think looking at your general company policies is one way of doing that. And if you can offer flexible working from day one. Now, before the legislation comes in, I guess it helps you stand out from the rest of your competitors. So, you know, there's strategic reasoning, I guess, behind offering it. And we know it's going to come in. So actually take the bull by its horns and have a go at introducing it before legislation. And that sends a massive message, doesn't it, to your employees? But that's interesting.
Absolutely. So the next one is linked to that, and that's, do you allow more than one request to be submitted in a 12-month period? Again, it'd be interesting to see whether this is also being more flexibly applied than the rules.
They can be hard to manage, can't they? Especially more complicated ones that take a few weeks to.
Okay, I'll close that one and share the results.
Okay.
So majority no, which is probably to be expected, because there is quite a long process potentially.
Yeah.
So if you've already turned one down or agreed one even, and all the things you may need to implement to allow it to happen, then it is a bit more of a challenging one, I think, to allow more than one. Okay, let's move on to the next one, which is the last one in this section, I think, which is, which of the following will have the biggest impact on your business of the ones we've just discussed? Okay, I'll close that poll and share the results. So yeah, it's the flexible working one.
Yeah.
I think removing that one per year is probably the most significant impact, rather than bringing it forward to the beginning, although, because you would hope that most discussions around flexibility would have been had at the recruitment stage.
Yeah.
You know what I mean, with the one from day one. But the actual allowing you to have more than one in a year might be
it's the
challenging.
management of it as well. And if you're, I don't know, if you're a contact centre environment, flexible working can be very one of the main types of employment relation cases, isn't it, to deal with. And workload is already sort of, the volume is already high, so to have two, there could be quite an impact. But ultimately, flexible working is, I guess, it's how working practices have evolved, especially on the back of the pandemic, and it's probably more the norm, and employees come to expect an employer to be able to offer.
Absolutely.
And carers leave, you know, more and more people are taking on caring responsibilities, aren't they? So 20%, it doesn't surprise me. But yeah,
absolutely. Okay, some more challenges ahead for us all.
Yeah.
Okay, back over to you.
Thank you. And this actually, back over to you.
Yes.
We've got some questions. Any come in?
Yeah, we have had a couple of questions regarding the this particular section. So I'm going to, in this bit, I'm going to include the questions around these topics, and we'll move some of the holiday ones to the section at the end. So, really good question, this one on carers leave. Can it apply to an elderly parent who does not live in the same household? Do we know yet?
So let me see if I can. Well, the definition. Let's just go back to my definition. Let's have a look. Spouse, civil partner, child or parent, live in the same household as employee. Now, the other, I think it can do, because there's something in the current bill that says they reasonably rely on the employee to provide or arrange care. So I think you would argue that if your parent, although they're not in the same household as you, they reasonably rely on you to provide them their care. So
Yeah.
I think it would fall in scope.
But we need I guess we need the full details to be absolutely sure
Yeah,
on that
but
one.
even then they may not define it. So if you think about dependency leave,
Mm.
there are still sort of like unanswered questions, and there's still an element of interpreting a situation as to whether it qualifies or not. So we may never get a definitive position. I think the fact that they've written reasonably rely on the employee to provide or arrange care,
Mm.
and I suppose it'll come to a case being tested maybe, but yeah, or it could be added in, I don't know.
we can hope. So the next question is about flexible working. It was just more an observation. Somebody saying they offer it after the probationary period is complete,
Okay.
rather than from day one.
Yeah.
And again, it goes back to, you would hope those questions have been had
Yeah.
during the recruitment stage, if there was some flexibility required on the contract that was being offered. Bearing in mind, if the day they start and you spent all that time and money and effort in recruiting them into the role you need filling, and then they submit a flexible working request, that's pretty challenging for most people.
Yeah.
So the next question, I guess, is around the neonatal, I think, is how would you classify a long-term relationship, i.e. not married but living together? I think that's,
Yeah,
is that
I
the same
mean,
as in the paternity and maternity, is it?
let me go back. Let me see. Parental or other personal relationship with a child who's receiving. I mean, you don't have to be married. I mean, as long as you have that personal relationship.
How they would assess it.
Yeah.
Sure.
That's a tricky one. I mean,
Mm.
it's going to
I think
be
it's what they
obviously.
say, isn't it? For paternity leave, isn't it the same though? It's a long-term relationship.
Yeah.
It's not. It don't have to be
You don't have to be
married.
married. You don't even
Um,
probably need to be together still. I mean,
no,
the parents
it's a
could be
longer
living
relationship with the
separately.
child, isn't it?
So it's about looking at that personal relationship with
Mm.
between them both, and with the child. And again, it's coming down to making a judgment.
How you'd assess that, I don't know, but that's an interesting one.
No, for example, you might have a grandparent and a young adult. That grandparent might be helping the young adult in bringing up the child. I'm just thinking, I don't know. And that grandparent then may request some neonatal care because they've got that personal relationship with the child, because they're helping their daughter or son in the bringing up of the child.
Yeah.
So
Interesting.
yeah.
I guess that one will come out with more information and potentially case law. So another one is, what proof will be accepted that would confirm an employee needs to take carer's leave? Do we know anything about the proof yet?
No,
I mean, that goes back to the previous one as well, doesn't it? How would they prove? What proof will they require for all of this? So yeah, we don't know those kind of details yet.
And that's probably what's being debated and discussed in various stages, and how that bill needs to look at the end.
And do you know if it covers parent-in-laws, or is it strictly the employee's own parent?
Let's have a look. So it's about a dependent, the carer's leave we're talking, aren't we? It's yeah. Regulations entitling an employee to be absent from work on leave in order to provide arrange care for a dependent with long-term care needs. That's literally lifted from the bill. So
yeah, and it's dependent. It's not, or a carer, isn't it? It's not just parents.
yeah, exactly. Yeah.
Yeah. So yeah, that would do. And finally, in this section, I think, should the flexible working be approved, would it become a day one right? And yes, absolutely. That is the
Yeah, it will.
intention of the
government have already
proposals
committed, have
anyway.
already said
Yeah.
they're accepting all the recommendations.
Yeah. So yes, it would. So yeah, fun ahead. Okay, I
Fun
think
ahead.
that's the end of the questions on this particular topic. So
Thank you.
carry on. Yeah. Thank you.
So that leads us on now to the third section of employment bills this year, and we've got a few to deal with that for equality. So so what we have in the first one is the Protection from Redundancy, Pregnancy and Family Leave Bill. So this stems back to 2019 when the government wanted to introduce legislation to extend redundancy protection for employees taking maternity leave. So just for clarity, the current law means that those employees on maternity adoption leave will have priority over other employees who are at risk of redundancy when it comes to suitable alternative employment. And that's written within the maternity and parental leave regulations. So what the government are proposing, what this bill is looking to propose, is to extend that protection. So because at the moment it's only when you're on maternity leave and it ends when you come back to work. So the idea with this bill is to extend the protection so it starts from the time the employer is notified of the pregnancy and would expire 18 months after maternity leave begins. So it's quite a significant bill in terms of, I guess, from when you're managing a redundancy project. The bill is at the House of Lords stage, so again, it's already gone through the House of Commons. It's had its second reading actually on the 3rd of March and is at the committee stage, but we're waiting for a date of that. So we're expecting to see that come in this year. So essentially, what it will mean for employers is when you're managing a redundancy project, you need to be considerate of not just those on maternity leave, but everybody that's pregnant and those that have come back from maternity leave in the 6 months. That's right, isn't it? 6 months from having, well, that's if they've had the 12 months off. 18 months after the start of the maternity leave is an easier way of saying it, because it just means that they would automatically get a suitable offer of alternative employment over any other employee. So they have that greater protection. So that's a big piece of news on that. We then have the Worker Protection Amendment of Equality Act 2010 bill. So we've had the Equality Act, you know, for years, and we're all familiar with how it operates. And what this bill will do is make employers liable for harassment by third parties. Those of you that have worked in HR for some time will probably remember it used to be an obligation when the Equality Act first came out, but it was abolished a few years later. But it just made it a legal obligation that for employers to take necessary steps to protect their employees from harassment from third parties. So it will introduce a specific duty on employers to take all reasonable steps to prevent the sexual harassment of their employees. And the bill again is at the House of Lords. Many of them are at the House of Lords. In fact, it's got its second reading on the 24th of March. And I think this just shows there's so many now at the end of the parliamentary, or coming to the end of the parliamentary process, because they've all been bubbling away in the background pre-pandemic. So they probably had a lot of their previous stages a while back, and they're all sort of caught up. So This one is significant, so we're going to see changes to the Equality Act and harassment. So there's going to be a lot of focus on ensuring employees have the right policies and procedures and steps in place to make sure people are protected. So that was a quick short update on family equality related bills. Do we have any questions?
Not on that section, so
No.
I
Okay.
suggest we continue and say capture all with the time we have. Yeah.
Thank you. So then this then brings me on to the final section, which is all looking at the bills that will impact on how we operate and our work practices. So first of all, we have the Employment Allocation of Tips Bill. So relevant for hospitality, of course, and it will basically make sure that workers receive tips, gratuities and service charges paid by customers in full and without deduction. It will mean that employers will be legally required to have a written policy when they award tips, service charges, etc., on more than an occasional and exceptional basis. So that's, again, it's been bubbling away. It was part of the employment bill that was pre-pandemic. Again, it's at the House of Lords. The committee stage is scheduled for the end of March, the 27th. So that will be a massive development for hospitality sector. And obviously the implications of that, clearly employers will need to have a specific policy being clear on how that is all managed. We then have the Strikes Minimum Service Levels Bill. If that became legislation, which highly likely it is, it will mandate employees working in 6 sectors to provide a minimum level of service when there is strike action. So some of the key sectors will be your health, education, transport sectors. The employer would be able to reasonably identify the staff that would be required to provide service, and the bill would also allow employers to take action when an employee breaches the minimum service level, so through the disciplinary procedures, etc. So it is very controversial. It's being criticised by the unions. It is at the House of Lords and the committee stage was held on the 9th of March, but essentially the government's aiming to ensure that disruption is minimised when there is that period of strike action. So that's coming through. Another significant piece related to work practices is the Code of Practice on Dismissal and Re-engagement. It's a new document that's been published. It's come about mainly on the back of the whole P&O ferries redundancy handling of last year, for those of you remember and joined our webinar at the time. The date of implementation is yet to be confirmed, but generally the advice is to employees is to consider as though it's in place because it's coming in. There's currently an open consultation going on seeking views on that draft code of practice, and that consultation closes on the 18th of April. So if anybody wants to participate, we can provide the links so you can do so. And the code of practice would apply to employers wishing to make changes to its employees' contracts of employment, and where an agreement cannot be sought, then the employer dismisses and offers re-engagement on new terms or new employees to perform the role. So as you'll remember, back in, I don't know, February, March last year, P&O dismissed about 800 employees and instantly gave their roles to third parties, agency staff on lower wages. And so this has come on the back of that because of the uproar that came as a result of how they handled it. So just to look at the code of practice, it's setting out several things. First of all, an employer must consider its business case in the event that agreement cannot be gained on proposals put forward. There's going to be certain actions required of an employer when sharing information. When multiple changes are being proposed, then implementation, where possible, should be over a period of time, not just all in one go. And crucially, changes that have taken place later down the line will require the employee to revisit their business case to basically consider, is it still relevant? Is it still fit for purpose and necessary? Because ultimately what you're doing is potentially dismissing somebody and putting them on new terms. So, you know, it goes without saying, I guess, if things aren't happening for another 6 months, a lot can happen in 6 months. So they're making that a code of practice. We then have the rehabilitation of offenders, and this is the piece of legislation that I talked about where it's gone through the various stages, it's been given the royal assent, and we just don't know the date of when it's coming in. So it relates to section 193 of the Police Crime Sentencing and Courts Act of 2022, and it's essentially the giving time spent for certain convictions to be reduced. Spent convictions obviously will then not automatically be disclosed on employment checks. So this summary, just to illustrate what the changes are going to be. So custodial sentences of up to 1 year, they'll be spent after 12 months without reoffending. Convictions of between 1 and 4 years will be spent after 4 crime-free years. And then those sentences over 4 years will not be automatically disclosed where there has been a 7-year period of rehabilitation. The changes aren't going to apply to convictions relating to serious sexual, violent or terrorist offences for which the sentence was 4 years or more. So as I said, it's already been given the royal assent, so it's now legislation. It was last year that came in. However, the regulations is to be brought in due course. So we don't know the date, but it's there waiting to be launched. So as I said earlier on in the seminar, just keep up to date on our main website. If you're knowledge-based users, we post updates all the time there as well. And then I did say earlier that we were going to come on to holiday pay again. So on the back of the Harpur Trust case, it triggered a government consultation that closed only recently on the 9th of March, and they have consulted on a new code of practice which will introduce various things. So the draft code would introduce new legislation to resolve the issues by allowing employers to pro rata holiday entitlement for part year and irregular hour workers. It would give them an entitlement proportionate to the number of hours worked. There would be a 52-week holiday entitlement reference period, so something that's specific and confirmed, no more of needing employees to make judgments as to how they work it all out. And it will be consistent with the pay reference period that I've talked about. So we have that already set in the Employment Rights Act, where you look at that 52 weeks. And it would require employees to keep records of time spent working, like the current obligations already around holiday pay and national minimum wage regulations. So keep an eye out on that. If any of you are knowledge-based users, you can access our calculators that we have available to help you calculate holiday pay, and we have guidance documents as well, which also includes some options for how you can approach calculating holiday pay, albeit none of them have been tested, but we set out where we think they can be fairly and reasonably calculated. We then have legislation that has recently come in. It's around the use of agency workers during strike action. So it came in because previously to last summer, employers were not allowed to use agency staff to provide cover when there was strike action. The government quickly passed legislation to allow it. So it's currently there. Employers can use agency workers, but what the trade unions and the Trade Union Congress are doing together, they've launched a judicial review on that. They believe that the Secretary of State for Business failed to consult, as is required by the Employment Agency Act of 1973, and they also argue that it actually violates trade union rights that are protected by Article 11 of the European Convention on Human Rights. So that's something to look out for this year. What will happen on the back of that review, Whether it'll overturn anything, I don't know, but that's just something just to be mindful about. We also have in the pipeline, and whether it's this year, it's a bit difficult to know, but the Bill of Rights, that would effectively repeal and reform the Human Rights Act of '98. Now, the Human Rights Act derives from the European Convention on Human Rights, which is a binding treaty, and it deals with a broad range of issues that would be the subject of human rights. So if you think about consent for you know, your medical consent and things like that, there's implications at the moment on human rights about protecting that. So that's in the pipeline, and we think it's going to be probably later this year, if not probably next year, we'll see developments. We also have a data protection and digital information bill, number 2, where if passed, then I think we're going to see some developments on data subject access requests, legitimate interests, the international transfer of data, and records of processing. So, for example, if you already deal with data subject requests, you will already be aware that there's a phrase, manifestly unfounded or excessive, which allows data controllers to charge a reasonable fee or refuse to act on an employee request. So what I think this bill is looking to do is bring a new standard for vexatious or excessive requests. Legitimate interests, it's about the requirement for data controllers to assess whether they have a lawful basis in processing personal data. So there's something in there around that, and of course how records are processed and the international transfer of data. So what we'll be doing is keeping an eye on that. It's not necessarily anything that's going to be coming up very soon, but we'll keep an eye on it, and we'll probably do a webinar on that subject, maybe bring in some experts on data protection as well, perhaps to co-host a webinar on that, because obviously it will be very relevant to employers. So this then brings me to the summary slide of what we've talked through. We've gone through an awful amount. There is a lot on. It is potentially going to be a busy year. And I think what we're going to do now, we've got some polls, and we've got something else that we're going to run as well shortly. So, Sue?
Yes, I'm here.
I think we have a further poll.
We do. So we have one poll at this stage. Let's just load that. So of the 4 main areas that Victoria's gone through today, which one do you think will be the biggest challenge? Nearly there, I think.
Okay.
Okay, I'll close that poll and share the results.
What have we got?
So the EU reform and revocation, which yeah we're all anticipating, has been a challenge, and the working practices, absolutely.
The EU, it doesn't surprise me, the EU one. So see how that evolves over the coming months. In fact, we are running a webinar, aren't we, in May on that. I think May the 11th, I want to say. So that's obviously free to everybody if you'd like to come along to that. So what have we got next? So this is just an opportunity before we move on to the practical side of implementing, and I'm conscious of time as well. So any questions at this point on anything that we've just gone in that last section?
Not that have come through on the panel on that particular section. So
okay, I'll move on. So now really is just looking at some practical guidance around dealing with all of these bills as and when they come through. And I think when it comes to the EU reform bill, then, as I said, keep up to date with our updates. We're keeping our eye out regularly. We're posting updates on our website and our knowledge base. As I said a moment ago, we are running our free monthly webinar. So that's on the 11th of May. They always run on a Thursday, the second Thursday of the month, 10 o'clock till 11. So it'd be great to see you then, have you join us. And then diarise 31st December, because that's a sunset clause expiry. So I would suspect we're going to sit here a lot more mid-late summer onwards, getting ready for the December, and so it'll be interesting to see how developments occur. So yes, that's what you can do in regards to the EU reform bill. In terms of family rights, then just make sure your policies and procedures are still appropriate. Update them as you need to with the new legislation that comes in. And obviously, with some of those family-friendly rights, there will be budget implications. So review your budgets associated to the family leave, and obviously a big thing is your line management training. That's always huge whenever anything comes in that's new. So think about how you can address and get your line managers trained on the developments. From an equality point of view, then it's not just line managers that need training. All staff should have equality, diversity, inclusion training. That's actually separate to the training you then offer line management. So line management training on EDI has a different slant and comes from a different perspective, but everybody ultimately in the workplace must have some form of equality, diversity and training. Review and amend existing policies and procedures. And with anything around equality where there's alleged breaches, then it's about acting on issues, doing so promptly, swiftly, and in line with your policy, so that everything is addressed. So in terms of those work practices, review contracts of employment to ensure you're complying with the exclusivity clause legislation that's come in. The Harpur Trust ruling, many people may have to revisit their holiday pay clauses. Look at how you calculate holiday pay and review, do you need to do it any differently? Bearing in mind the consultation that's gone on, that's closed, we should probably be hearing in the next month, 2 months about the outcome of that consultation. Review processes for distributing tips. Review recruitment policies and procedures, and of course those businesses carrying out project plans, redundancy project plans, just make sure that you're being considerate of those out of the business on maternity adoption leave because of the greater protection rights there. This is just a summary of what I've just gone through. And then I just thought I'd run through around introducing new policies and procedures. I'd say there's several stages to it. Obviously, when you do so, there's additional costs associated with employment law changes as well. So review budgets, plan how the company will become compliant with the new laws. It's about communicating with the workforce those new policies and procedures to make sure everybody is clear, understands them, follows them as they should. And a big part of that is your training of your line managers and employees, depending on obviously what it is that you're introducing. And of course, as with any policy, use it, review it, how has it been implemented, monitor changes in employment law so that you can evolve that policy as you need. And here's some just bullet points of what we've just gone through there. Now we're coming up to our final few polls. We've got an interesting new thing we're going to try with everyone. So Sue, if we put the first poll up, which is a normal GoToWebinar poll.
Yeah, it's launching that one there for you. So what help do you need to remain compliant in 2023 and beyond? And just in case you're wondering, that this information that we're collecting will enable us to provide this information for you. So we will look at, you know, the kind of support you need and help, and try and develop materials, tools, whatever we feel might be useful to people facing these challenges. So we do gear our webinars, our sort of topics that we do every month, and our the supporting documentation that's needed is all geared to what people want and need. So we find this really, really useful for our own development, so that we can make sure we are matching what people want. So I'm going to close that poll and share the results with you.
Okay, well,
there you go. Kind of across the board,
similar.
really.
Yeah.
Quite even.
Yeah.
But particularly the updating policies and procedures, and that is a key focus for us, of trying to keep abreast of all these multiple changes that are going to come in. I guess in some ways there's advantages if they all come in at once.
Yeah.
But most likely they're not individual. So yes, it's there could be quite a lot of change and training needed for staff, particularly for managers, in making sure they don't inadvertently kind of breach all the new regulations coming in. So
okay, brilliant.
Okay.
So now, Sue, we're going to try something new. So we have done this on a webinar before, so if any of you have joined, I think it was the January one. So if you have a mobile phone, or if you have access to the internet on another screen, so you can still see the webinar as well, then if you'd like to take part in this test, it's about just seeing where you rank in order your priorities for 2023. So if you either scan the QR code here or go to www.menti.com, it should be self-explanatory in that there should be a field on your screen that asks you to enter a code. And I'm going to now try and share my screen.
Actually, if you scan you don't need the code. If you go to the website, you'll need to type in the code, and then you get a drop down asking you to select.
So can everybody see it moving? Have I shared the correct screen now?
Yes, that looks good.
So it works. They're still getting some votes. It's all jigging about. So this is rank in order your priorities.
That one just swap place.
Yeah. So that, just looking at the exclusivity clause at the bottom at the moment, is still moving. That goes back to our very first poll, where 14% of everybody said that they have workers who earn less than that 123. So actually, it's an issue not for a big proportion of you on the call today. Holiday pay, okay, brilliant.
Okay.
So that's really useful, thank you. I'm going to just change my screen back. So can you see the correct one? Brilliant.
Yes.
So we're now on to our final question slide. So almost like our mop-up questions. If anybody has raised any more that we want to go through, obviously with timing wise, if we run out of time, then we can get back to people. We might just pull a central document together, Sue, to share out.
I think so, yes. There are quite a few from before. One or two got answered in the last section, but they're mainly around the holiday pay and calculations and things. One, first of all, is this is somebody who they allow a 5-day carryover when their entitlement is 32 days holiday annually, and we're saying, does that mean that it's unlawful? But actually you're okay. It's the 4 weeks minimum, isn't it, that you the statutory leave that you can't carry forward, but anything above that, it's
Yeah.
not the full 5.6, it's just the 4 weeks. So that policy would be absolutely fine. One question was around the rates. I think they've just been published, haven't they, the statutory redundancy pay, and they'll be on our key employment statistics page.
Yeah.
So is it changing in April? Yes, it is, and they have increased the rates, and they are now available.
Yeah.
And there's a different date for commencement in April depending on the rate,
Yeah.
isn't there?
Yeah, that's right. So it's
Yeah.
things like the national minimum wage comes in on the 1st. Then you have your statutory family friendly rates, I think, don't quote me, the 6th. It's on the we've got a document on the main website, knowledge base. So yeah, sorry, I should have put that on that earlier slide, the actual date. But yeah, it's the first few days of April.
Yeah, and they are slightly different depending on the actual rate. So going back to variable hours and holiday entitlements at the moment, and how they calculate them, if it's hours or days. So there's a couple around this. So one is with a working pattern that's different on different days of the week. So they've got one working pattern for Mondays and Thursdays and a different one for Tuesday, Wednesday and Friday.
Yeah.
They would receive 22 days leave, and they're saying should they calculate it in hours and not days. I think the advantage of doing it in hours is that if they booked a Monday or a Thursday off, they would need to take a different number of hours off as if they were booking a Tuesday, Wednesday and a Friday, which are shorter days. So I think to be fair on the employee and to allow them not to use, it depends, I guess, if you only allow a day off as opposed to people can take a couple of hours off to attend a appointment or something, then you can just say a day is a day, and it won't make much difference in a 5.6 week or whatever entitlement. But if you do allow more flexibility with the time that they can take, then hours usually is better. Especially when the hours worked on each day is different. Would you agree?
Yeah, absolutely. The hours, working in hours, just gives you more flexibility. So I suppose as well, it's what kind of policy do you want to operate in your business? Are you happy people taking hour here, hour there kind of thing, as and when they need it, or are you do you need them to be in for either half day, full day kind of thing? But yeah.
And so this one's about carry forward. Are employees on long-term sick legally entitled for their annual leave to be carried over to the next year? The simple answer is yes. They are. Zeros contracts that work constantly for seasonal peak, i.e. 10 weeks, then nothing for many weeks, working only occasionally through the rest of the year. How do they calculate holiday pay due?
Well, they'll fall under the Harpur Trust case ruling. So they need 5.6 weeks of paid annual leave. That's a definite bit I could tell you.
That's the entitlement, isn't it? Yeah.
And that's the entitlement, and then calculating pay. So you need to get a suitable reference period to look back to find an average working week or working day in hours or days.
And then
once you've found an average of that, you then calculate what that average pay is by looking back your 52 weeks, which is what's in the Employment Rights Act. And then it's trying to use a formula to work out what 1 hour equals in pay to holiday.
Okay, thank you. So going back to compressed hours and holiday entitlement in days. So if they are working regular hours over Monday to Thursday, should the entitlement reduce by 1/5? So that when they take 1 week's leave, they only take 4 days to cover the week, which absolutely, yes. If you do it in days, then yes, it is 4 days because a week is 4 days. So yeah, you would, if you're using days in your entitlement, then you would reduce it.
So for example, I work regular hours, but I do 4 days. I get 5.6 weeks paid annual leave, but that equates to 22.4 days.
exactly. So, and somebody was asking how to calculate holiday pay for those working compressed hours, but if they're regular compressed hours, then they wouldn't fall under the
No, that's
Brazel,
right.
but you would calculate it. Pay is, it's a week's pay. They're still working their contracted hours, so
Yeah,
a week's pay is as normal, and a day's pay is, it'll be, if it's a 4-day week, it'll be a quarter of the week's pay, wouldn't it?
yeah, yeah.
That day. So that should work
Should.
out quite well. Let me just see. We have bank staff classed as 0 hours. Is it unlawful to use the 12.07% method for holiday calculations?
Yes.
Yeah, I think is the quick answer.
Sorry to say.
Yeah. Can you force staff to take leave if they've barely taken any over numerous years? I guess going forward, they can't do much about the historical, but you can encourage, can't you? But
You can.
and you can minimise the carry forward options. You know, you can manage it, but you can't actually force people, can you?
No.
Unless you have compulsory periods of leave. So if it's an issue more generally across your workforce, I guess you could have shutdowns, or you could
Yeah.
say you need to take X days leave within this quarter, X days leave within this quarter, and stagger it so that you don't have everybody off at once. I guess it's just whatever suits your business, and I guess you need to have more, maybe stricter policies in the taking of leave, or processes for encouraging the taking of leave, because it's a health and safety angle. Then I guess you need to make sure that you do insist people take at least 4 weeks leave before they carry forward any, for example, and things like that. So it is a management challenge, I think, that one. Somebody was asking for clarification around the earlier question, which was, if someone's part-time with regular hours but does regular and consistent overtime, would this ruling still apply? I think no, because they're part-time with regular hours. So no. And I think our last question is, so this I think was around the holiday as well. Was it flexible working? Why does it not apply to part-time or fixed-term contracts if the term worker is broad in the working time regs?
Oh, right.
We maybe need to seek further clarification from the...
Well, it's, how do I answer that quite succinctly? I think if we put a general Q&A document out on the back of this,
we can come back.
We'll incorporate that. The issue
it's probably
with
quite lengthy, isn't it?
Yeah, but in short, the issue with the irregular hours, you don't know what a working day is. You don't know what a working week is, because they just have no pattern to it.
Yeah.
Somebody that works regular part-time, you know what a working day is, you know what a working week is.
Yes. Okay, so we have a few more on a few different questions, a few different topics now. Okay, so we will put more information out on some of these that were particularly more complicated to explain in a short period of time, but we will put out a bit more information. So if somebody is in a redundancy pool and they are on maternity leave, would they be protected, i.e. their scores wouldn't be counted, or is it just that they would have priority over any alternative positions?
They get priority. Yeah. So if you've got suitable alternative work, they would be given that job.
That priority, yeah.
Yeah.
What are the current rules around dependency leave? What proof can an employer ask, and do they need to give any notice to take dependency leave?
So there's no notice, because essentially it's an emergency.
Kind of emergency, isn't it?
Yeah, you can't plan. If somebody's saying I need next week off on Friday, it doesn't technically fall under the dependency leave regulations. So it really is an emergency. So you make a phone call that morning, you know, Sue, I can't come in, or this has happened, kind of thing.
Yeah.
And it's about taking the time out of work to make arrangements for the care or in some cases if you need to provide that care, but it's about looking for care, and typically, normally 1 day is generally a reasonable period of time to need. Normally,
Yeah,
I say it, nothing's set in stone, is it? Nothing's straightforward,
absolutely.
but there's always circumstances. But yeah, so yeah, so you can't plan it. It's on the day, it's an emergency situation, it's for a dependent, similar to the definition I went through with carers. So somebody that relies on you, reasonably relies on you. And in terms of evidence, I mean, I guess you can have a policy, so it's a blanket approach, so you're not singling out people that, I don't know, you need something on the back of it, but it's not, I don't know what your thoughts are, Sue, on that.
I don't, yeah.
I think a lot of it is trust, you know, that employee, if you know your employees, you know their circumstances, their family setup, and so if somebody's phoning you on that morning, I can't come into work because of X, Y, Z, it's unlikely to be a shock because you generally have a feel for your employees, if that makes sense. And you know, if that situation has happened, you just need to allow them to utilise that entitlement a day's unpaid leave.
Yes, yeah, absolutely.
So
Okay. Let's just have a look. There's quite a few questions coming in, so we're not going to get through all of them, but we will try and put a Q&A together and come back afterwards. Another one around proof. So for the fire and rehire, the new variation to terms, what proof must employers show that they need to essentially reduce pay, overtime or premium benefits, i.e. sick pay? So I guess it's the business case again, isn't it?
It
It's
is.
just having a solid business case that identifies why the business is struggling and proving through the business case that they need to take action and what options they've got. One is to make people redundant and manage on less staff, or try and keep everybody but reduce pay or anything contractual overtime. I guess if it's not on contractual overtime, then you can just stop it. But contractual overtime, you would need to renegotiate.
I think if it goes back to your business plan, like you said, your business case, because well, you will be setting out the cost implications and what's driving the business to make that change, and it will incorporate somewhere the financial position of the business, won't it? And it's just how you collate all that information, have it documented, so if you are ever challenged, you've got that audit trail. I know on our knowledge base, for example, we have a template business case, and it's got specific sections to answer in compiling it. That's your evidence.
Yeah, absolutely. A challenging one. Do we know on the tips legislation, do we know, will an employer be able to simply ask staff to reject any tips?
I don't know about that, and I don't know if that would be, because if you think about the workers that would be employed in those kind of jobs, low earners, I think that would go against the spirit of the legislation, because it's about how enabling them to, I guess, from a fairness point of view, benefit from the gift that the customers are giving. I don't think that would be part of it. It goes against the bill, I think.
Yeah, agreed. So
but that's just my view.
Yeah, quite. I agree. I think, how are we doing for time? We could probably ask a couple more.
Okay.
So somebody's asking the question, staff on part-year contracts,
Yeah,
would they need to be paid a minimum of 46.4 weeks pay?
they get paid 5.6 weeks
Holiday?
holiday.
Yeah. But
Sorry,
they'd have to be paid a minimum of 46.4 weeks pay. I don't think there's a minimum in how much they have to be
you pay.
paid.
No, yeah. So if you think about in the Brazel case, Brazel, they were paid by the hour for the hours they worked.
Mm,
So that's how you pay anybody else.
yeah.
You pay for the work undertaken.
In the normal pay, yeah. It's just
In the normal
holidays
pay,
that have changed, isn't it? Yeah.
it's the holiday. Then you have to make sure that you're paying 5.6 weeks. But
Equivalent. Yeah.
what a week looks like for that person is not known. You have to work that out.
Yeah.
Yeah.
So it's just entitlement, the 5.6 weeks. It's not pay.
Yeah. Yeah.
Yeah. Okay. And for the carers bill, will the employee be required to provide evidence?
I don't know.
We don't
Actually,
think they've not clarified that yet, have they? Because that was one of the things that we need to kind
Yeah,
of
we'll find
wait
out.
for more guidance on. And the rehabilitation legislation, do you know if it applies to businesses who have to do enhanced checks due to the nature of the business? I don't know whether they've...
I think it's all about what's automatically disclosed, isn't it?
Yeah,
So
yeah.
that applies basic and enhanced, isn't it? As a conviction is spent, if it's as soon as it's spent, then it'll be disclosed.
Yeah.
So regardless of the type of check you're getting, so it'll apply all around.
It'll just mean you either will
Yeah,
get or won't get
yeah,
feedback on the check, I guess, depending on the timing.
yeah.
Right. As there's an additional bank holiday this year, can an employer force you to use your statutory annual leave entitlement as opposed to having unpaid leave?
Um,
I guess you could
so
give twice as much notice for them to take leave on that date.
say
2
that
days
again.
notice.
So they've,
As there's an additional bank holiday this year,
yeah, yeah.
can an employer force you to use your annual leave entitlement as opposed to having unpaid leave?
I think you need to look at the contract, because if the contract says you're entitled to all bank holidays but doesn't specify numbers, then they get it. If your contract says you're entitled to 8 bank holidays each year, then obviously you have this additional one. You don't have to offer them to be off. They can be in work. Yeah, so working this through, you would give them double the notice. Is that what you just said?
Yeah.
Yeah,
So
sorry, I was
I
working
think
it in my head.
it does depend what the contract says as to the
Yeah.
entitlement, and you can, with any leave, you can give twice as much notice as the amount of leave you wish employees to take. Obviously, you need to be reasonable with it, because if you're too far into the holiday year, then they might not have enough to take when you need them to. Normally people do it at the beginning of the holiday year and say, we want to shut down this Christmas. You will need to take 5 days of your leave to cover the period of shutdown, or but in this circumstance you could say, we're not going to open. If you want to be paid for it, we need you to take some of your entitlement to be paid for it, and therefore we're giving you notice that we will require you to use some of your leave.
Yeah.
And if you haven't got any entitlement left, then you will have it as unpaid.
Yeah.
So, but yeah, there's always little nuances, aren't there?
I know.
I think we've probably, there are a few more, but we will collate all those responses and
Yeah, we will.
come back to you all, because some of them are quite, the ones I've left need a little bit more detail, so I don't think we've got enough time now to cover them all.
No, and we'll hopefully I'll be able to get something pulled together by the end of this week, but if not, it'll be next week. Definitely, we'll send something out on that. So if I just move the slides on. So really, as we usually like to do on the end of our webinars, it's just letting you know about the training and webinars we have to offer. So just before we close for the day now, so this is all the training courses that we offer. That CPD registered and count towards CPD points. We also have health and safety. We've got a couple of training courses coming up in April, but there's a lot that we offer, including we do a lot with mental health as well, whether you want some workplace mental health ambassadors, qualified health and safety first aiders, we do a lot of that. We do have one final poll. It's if you'd like us to follow up with you about any of our services today, whether it's HR, health and safety, the knowledge base. I've talked about that a few times. That's where we have all our template policies, letters, articles, everything you could possibly need, or payroll and training. Then do let us know and we'll be happy to follow up with you on that.
Just letting that run another
Okay, let me know when you want me to move on.
So there's a lot of things just coming through.
It's okay.
Okay, I'll close that now.
Lovely. And just to let you know as well, we've recently published this year's SME business survey. So for the last 3-4 years, we've been surveying SME business owners, getting their insights and views on key business matters. So this is the latest version. It was, the data was gathered December time. Obviously we've gathered that, analysed it, and we've provided it all in a report, which you can scan this QR code and get your access to a free digital copy. It's a really interesting insight actually, and sharing with us really the top concerns, challenges, priorities for SME business owners going into 2023. I've mentioned webinars. We run them every month, second week. It's always a Thursday at 10 o'clock. And we've just added to the schedule. So what you'll find is we have the EU law one coming up in May. And then the latest ones to be added is we're going to be dealing with 4-day working weeks, the practical sides, the pros and cons of adopting one. And because the recruitment challenges continue, we're running one around recruitment and, you know, why businesses need to take a different approach. Skills is also a big area where employees need to focus on the back of the pandemic. So we're going to be covering off building skills and capabilities of your workforce, looking at how employers can become age friendly, looking at both all ends of the spectrum. That's in September, and then there'll be an immigration developments update, see if there's any things to keep an eye on there. That'll be October. So simply go to our website, QR code is here as well, or if you're knowledge base users, there's events page as well. And that just leaves me to say thank you everybody for listening to Sue and I for 2 hours, talk about everything HR, a lot about Harpur Trust, and taking all of your questions, which have all been interesting, and we will get back to you all on those. Thank you, Sue and Drew, for your support on the seminar this year. And that's it from us, and hope to see you all on our webinars next month. Thank you.
Thank you to you, Victoria, as well. Thank you very much.
Thank you.